Good morning, everybody. My name is Kim Tully from Engaging Dementia, and we're very pleased this morning to have Mark Felton along. Mark is a solicitor based in Greystones, and he has practiced extensively in the area of mental health law and capacity law.
I am a solicitor. I'm based in Greystones in County Wicklow, and I do practice extensively in the general area of mental health law. So across the range of areas that people can have difficulties with, not just in relation to enduring powers of attorney, but in relation to people detained under the Mental Health Act, for example, or in relation to people who do not have enduring powers of attorney and need to have their affairs managed and therefore need to be made wards of court, and various other matters related to that particular area. So what I'm proposing to do just is to approach the topic in a conversational manner rather than a necessarily overly legalistic manner, and I hope that meets with everybody's approval. So what I'm going to start out by doing is just discussing the notion of the enduring power of attorney and suggesting why I think personally it's a very important document and one which I highly recommend that everybody should put in place. And then, time allowing, we might venture into what happens in the event that somebody who has an enduring power of attorney does lose their capacity. And in those circumstances, what does one need to do in order to activate the enduring power so that the nominated attorneys can actually take over the management of that person's affairs? And then there are also issues around potential areas of dispute and what happens if there is a dispute and how does that get resolved, and ultimately what does that all look like. So from a point of view of the creation of an enduring power of attorney, I'm going to assume for my own ease more than anything else that we're starting at the beginning and that those of you who are tuned in have little or no knowledge of it. And I know that's not the case, but you'll excuse me if I start on that premise. An enduring power of attorney essentially is a document that anybody can sign during their life while they have full mental capacity to do so. And it is a document that enables them to choose who they wish to take charge of their affairs, both financial affairs and personal affairs, in the event that they lose capacity at some later date. I very often liken it to an insurance policy. It is a document you have to buy into at a time in your life when you're capable of fully understanding it. And it is a document that we always hope is never going to be needed. And of course, none of us is naive enough to realize that things don't happen and people's capacity to manage their own affairs can be changed for a variety of reasons, and therefore enduring powers of attorney are very important documents. So the starting point is to decide who it is you wish to nominate to be your attorney. And generally speaking, in my experience, people will choose a close member of their family to be the attorney in the first instance. And even more specifically than that, I would say in the vast majority of cases where spouses are putting enduring powers of attorney together or thinking about it, they generally both do it at the same time, and they generally both appoint each other to be their attorney in the first place. So that would generally be the starting point. There isn't any specific limit on how many people you can appoint to be your attorney. But again, in my experience, and not surprisingly, the more people you have as your attorneys, the more likelihood there is that there could be conflicting views in relation to the management of your affairs if it came to it. So generally speaking, what I find is that people will nominate their spouse, if they have a spouse, or their partner, and they will make that provision first and foremost. And then we will have a discussion about who do you want to look after you if something also happens to your spouse or partner? And what can you do in those circumstances? And the answer to that is very clear. It is clearly provided for under the legislation and in the documents that you can also appoint one or more people to be what are called substitute attorneys. And they would be people who would step in the event that something has also happened to the original attorney and that person has become incapable. And I see variations of this from time to time because in some cases, people will appoint, for example, their spouse and a child to be the first attorneys, and then they will make a provision for one or more additional people to be the substitute attorneys. And in some cases, they will want the substitute attorneys to step up and become a full attorney if something happens to only one of the original attorneys, or in some cases, they will say that the substitute attorneys are only to become involved if something has happened to all of the people who have been appointed as the original attorneys. And that's just a personal preference, and it's a discussion that would be had when the document is being put in place. And again, there's no restrictions on the amount of people you can nominate to be your substitute attorneys. You can have one, you can have more than one. I think the most I have ever appointed as substitute attorneys, I think off the top of my head, is 3. And that's all fine. And if people want to appoint more than that, they can. But I would always caution against having more than 2 or 3 at the absolute most, due to the possibility that there might be issues then later on in relation to the management of the person's affairs if it becomes necessary for the document to be activated. So those are the primary, those are the 2 most important points that have to be considered. And the reason it's very important to consider carefully who you want to choose as your attorney is that you are going to be giving them effectively full control over all of your property, all of your finances, all of your affairs. And if you choose to do so, as indeed I would say 95 probably % of the people I do enduring powers of attorney for do, you're also going to be giving your attorneys your permission to make personal care decisions about you. And those personal care decisions can be a very important, if not one of the more important aspects of the management of somebody's affairs. And those decisions are set out, a summary of them is set out in the enduring power of attorney, and they are listed as being things like making decisions about where the person lives, or who they might live with, or who they might see or not see, as the case may be, or indeed things like their diet and their dress, and inspection of their personal papers. So effectively, all of the day-to-day decisions that we all make for ourselves, you are, generally speaking, allowing your attorneys to make for you. And therefore, it's very important that in choosing the person you propose to nominate as your attorney, that you would think carefully about it and make a decision based on not only the fact that you fully believe that the person is trustworthy enough to be given this authority, but also that you fully and completely believe that, for example, they're not going to suddenly decide that you like broccoli to eat for your dinner, never having had it in your life, and tell whatever institution the person might be in that that's what you love, when actually that's not the case. So these, that might sound like a bit of a flippant remark, but it is something that the attorneys would in fact be able to choose for you. And it's therefore very important that you can be certain at the time you put the document in place that you fully and completely expect that the attorneys will do what is the right thing for you. Because ultimately, the attorneys are going to be able to do whatever it is they think is in your best interests, and they are going to really, and we might come on to this if we have time, attorneys really are not accountable to other family members in relation to the decisions they make. So it's important that the attorneys are somebody who you fully and completely are comfortable with from the outset. So once you get over the issue of who you're going to appoint as your primary attorney, and then are you going to appoint a substitute attorney, and there's no obligation on you to appoint a substitute attorney, but I think it is very important, and I will just outline briefly why I think that is the case. And the reason for that is that if you don't appoint a substitute attorney and you've only appointed one or even two original attorneys, if something should happen to both of the original attorneys and they have both suddenly for some reason become incapable of managing your affairs, the whole enduring power of attorney will fall apart and be completely invalid, and your affairs then will have to be managed by you being made a ward of court, which is what the enduring power of attorney process is designed to avoid. And I have the experience of that happening on one occasion where somebody appointed two much younger people to be attorneys for them, and then completely and utterly unexpectedly, within a very short space of time, both attorneys unfortunately died suddenly, leaving the individual with nobody to manage their affairs. And they ended up having to be made a ward of court, which of course adds additional cost, which wouldn't otherwise have been expected. So I always recommend people to appoint substitute attorneys, but it's a personal decision at the end of the day. So once we have decided who we're nominating as the attorneys, there are other formalities in relation to the setting up of the enduring power of attorney. And those require, firstly, that a minimum of two people have to be formally notified of the fact that an enduring power of attorney is signed. And the regulations in relation to enduring powers of attorney, which go back to the 1996 Powers of Attorney Act and the Enduring Power of Attorney regulations, sets out a list of the priority of people who have to be notified when an enduring power of attorney is signed. And for example, not surprisingly, if you are married and if you are not nominating your spouse to be one of your attorneys, your spouse must by law be notified formally of the fact that you have signed an enduring power of attorney. And then after that, the requirements are that at least one person in the next closest degree of blood relation to you must be notified of the fact that you have signed an enduring power of attorney. So two people can be notified. You can notify more than two people if you wish to do that, but it is very important when you are considering who is going to be notified that they do fall into the correct bracket of priority. And the reason for that is not because it invalidates the creation of the enduring power of attorney, but it will certainly create difficulties in relation to registering the enduring power of attorney if it subsequently needs to be registered. And by way of example, I can indicate that we created an enduring power of attorney some years ago for somebody whose children were going to be the attorneys, and that was fine. And after the children, there were no other blood relations of any description that could be notified. So we went to the bottom of the list of brackets and we notified friends or spouses of children, I think at the time. But then when the time came to notify, to activate the enduring power of attorney, the individual who had grandchildren when they signed the enduring power of attorney, but who were under 18 at the time, those grandchildren were now over 18. So by law, when we came to register the enduring power of attorney, not only did we have to notify the people who we originally informed, but we now also had to notify the grandchildren who were over 18 because they were the next closest degree of priority. And that was a query that the Boards of Court Office issued to us that we had to deal with. And it's not that it complicated the matter unnecessarily, but it's an indication of what can happen. So you choose who is going to be notified. They have to receive a formal letter that has to be sent to them by registered post. And that will include a document that will be signed by you, which simply says that on a particular date, you signed an enduring power of attorney nominating whoever it is you have chosen as your attorney, and that then goes off by registered post. So that's one of the formalities that has to be addressed. One of the other formalities that has to be addressed is that once you have signed the enduring power of attorney, it must immediately then be signed by your GP, or if you're already being attended, or if you're already attending a consultant, for example, as some people are, by the consultant. And your GP has to, who is generally the person who signs it, has to sign a certificate to say that at the time you signed the enduring power of attorney, you were capable of understanding the nature and the content of the document. And the GP generally is, according to the regulations, obliged to sign that within a month of you signing the document, because obviously capacity and mental capacity can fluctuate and it can change over a period of time. So it's important that the GP or the doctor who's signing it signs it as close to the date that you signed it as it is possible for them to do. And that generally requires you to go and visit the GP or the consultant and get them to sign off on that for you. So the document gets signed by you, it gets sent to the doctor signs the certificate, and then it comes back to the solicitor. The solicitor also has to sign a certificate in the document to say that as far as they were concerned, on the day you signed the enduring power of attorney, that the solicitor was satisfied that you understood the document and that you were capable of understanding it, and more importantly, that the solicitor was satisfied that you were not under duress at the time you signed it. And generally speaking, from a solicitor's perspective, there is an obligation on us to have a one-to-one meeting with the person who wants to sign the enduring power of attorney on their own without any other family member being present, so that we can establish ourselves whether or not we think the individual is there of their own free will and that they fully understand the document. And that's an important part of it. And clearly, when spouses are coming in to sign enduring powers of attorney, personally, I think it's appropriate for the solicitor to meet with both spouses at the same time, because they will both know what they're doing already. But certainly in cases where other family members or third parties, as sometimes but not often in my experience happens, a carer, for example, might bring somebody in with a view to creating an enduring power of attorney. And it's important from the solicitor's perspective to ensure that the individual is there of their own free will and does comprehend what they are going to say. And then as to the capacity, mental capacity piece, whilst the solicitor plays a role in assessing the capacity as regards the person's understanding of the document, the doctor will sign off on the capacity and will sign the certificate to say that they understood. So the document will be signed by the doctor and it will come back to the solicitor. At that time, the next part of the process requires the solicitor to arrange for the document to be signed by the people who are being nominated as the attorneys, because they have to sign the document to say that they accept the appointment as attorney and that they understand the obligations that are being put on them by being appointed as attorneys. And those obligations, as I said earlier, are very onerous, and therefore the individual must acknowledge in writing that they accept that they have a responsibility to manage the individual's affairs properly, and that they accept and acknowledge that they understand that, according to the regulations at least, they have an obligation to apply to have the document activated if they become of the view that the person is losing or has lost their capacity at some later date. Now, insofar as the activation of enduring powers of attorney is concerned, in my experience, that tends not to happen at the very first sign that somebody might be becoming a little forgetful. It tends to happen much later on in the process, and it will only happen after a doctor has certified somebody in any event. So the solicitor will generally send the enduring power of attorney to the attorneys to sign. They have to sign, their signatures have to be witnessed. The document then comes back to the solicitor, and if there are 3 or 4 attorneys, it has to keep being sent off to people unless the attorneys live locally, for example, and can call in to sign it. When the document has been signed by all of the attorneys, the solicitor then also has to create and complete relevant affidavits of service to say that they have complied with the formalities in relation to the service of the notice on the people who are being notified. And those affidavits have to then be kept very carefully with the original enduring power of attorney in the solicitor's safe for safekeeping. And from start to finish, in relation to the creation of the enduring power of attorney, I would say it could take anything up to 3 months, maybe 4 months sometimes, by the time the document is sent out to all of the attorneys, and that it is examined and signed and sent back to them. And obviously, in some cases, people aren't great at sending things back when they're asked to, and it's just something that solicitors need to keep an eye on, and generally, in my experience, do. So there's a lot of information at the start of an enduring power of attorney document, which sets out the extent of the powers that you would be giving to your attorney should you choose to appoint an attorney. And as I've said, essentially, attorneys are going to be able to do for you exactly what they like in relation to your affairs, as long as they can justifiably argue that what they're doing is in your best interest. So they would be able to, for example, use your money in whatever way they feel you would otherwise have used your money and your finances, as long as justifiably, in their view, it is in your best interest to do that. So, for example, it wouldn't be uncommon for attorneys to make a donation of some money to a charity at Christmas, for example, if that's what they felt you would otherwise have done, or you had a history of doing that. It wouldn't be unusual for attorneys to give a birthday gift of 50 or 100 euro, for example, depending on what the state of your finances was, to grandchildren on your behalf, if that's what you would otherwise have done. So it's a broad range of authority that you're giving to the attorneys, and they can do essentially whatever they like. I would always caution attorneys that they need to keep good records of what they're doing, so that if they are ever called to account in relation to how they're managing your affairs, that they would be able to do that. So insofar as the creation of the enduring power of attorney is concerned, it's important from the solicitor's perspective that they go through all of the various rules and regulations regarding what the attorneys can do, because the solicitor has to sign to say that as far as they were concerned, they'd explained all of those points to you and that you understood them fully. Kim, do you want to jump in there? Are you all
Yeah,
right?
Mark. No, that's been excellent information. I was just going to say we've been getting a lot of questions.
By all means, let's have a few questions.
Very good. No, it's extraordinarily interesting, but we've got about 10 questions lined up, so I'm going to just roll through those. So the first one is what to do in end-stage dementia when feeding is no longer safe if the person does not having a living will.
Yeah, and that's a very difficult question, because essentially the enduring power of attorney doesn't offer and doesn't give the attorneys any authority in relation to personal care decisions. So those are decisions that still rest with the treating physicians, and that's why it's important that if people have a specific view on the treatment they do wish to be subjected to in an end-of-life scenario, that it is documented. There's plenty of cases in the High Court over the years accepting that if it is documented, the person's wishes will be respected. But if it isn't documented, it's a different question, and it will fall to discussion and or negotiation with the treating physicians, I'm afraid at the time, there is a possibility that under the Assisted Decision Making Capacity Act, if it ever gets activated fully, that will change to a degree, because there will be some additional authorities given to attorneys, but that's not the position at the moment. And I think to get into a discussion about that would just confuse the issue. But at the moment, there is no authority for attorneys to make those decisions, and it's a question of discussion and hopefully reasonably empathetic discourse with the treating doctors.
Very good. So the next question is when communication is so impaired, how can a person living with dementia make a will and make choices around where they live and what should happen to them and their estate?
If their decision-making capacity is that impaired, they cannot make those decisions, and another means has to be found to have somebody appointed to make those decisions for them. And if they have not put an enduring power of attorney in place, the only way in which that can be done under the current regime is for them to be made a ward of court, and for a person or persons to be appointed as the committee for the individual, and those people will then be entitled, subject to approval by the High Court, to make relevant decisions for the person. But there is no authority either under an enduring power of attorney or under a wardship regime for the third party attorneys or the committee to make a will for somebody. If they haven't made a will, well, then their affairs will be distributed in accordance with the rules of intestacy when they die.
Okay.
And that will depend on who their next of kin are at the time.
Very good. So the next question is around the benefits and drawbacks of having more than one person on the enduring power of attorney. I think you answered that one. But there's a specific question here about my father has Alzheimer's and currently has one sibling. Only one sibling has the enduring power of attorney. We're thinking of adding 2 more siblings to act, as the sibling lives abroad for most of the time. Is it okay to have 3 altogether to share in the decision making and make financial planning for our dad?
Well, the answer is that if that individual already has dementia to such an extent that the enduring power of attorney has needed to be activated, there is nothing that can be done about that now. It is possible, while somebody has capacity, for them to revoke an enduring power of attorney that they have created and to set up a new one, appointing more people. But if the document has already been activated, the only way it can subsequently be altered or cancelled is by court order. And that is why, as I said at the start, it is really, really important to consider carefully the nomination of attorneys when you're setting up the document.
Yeah, very good. So the next question, are there any potential negative consequences for choosing enduring powers of attorney versus a normal power of attorney? Trying to decide which one to apply for.
Well, they're 2 completely separate and different things. A normal or current power of attorney can be signed by anybody at any stage in their life while they have capacity, authorizing a third party to have their permission to assist them in relation to the management of their affairs, or in relation to the management of one or more specific matters for them. And that document will only last for a specific period of time, or until the individual loses capacity. And if they lose their capacity, that current power of attorney becomes null and void immediately, and the enduring power of attorney, if it is in place, would kick in from that point in time. Therefore, very often people will do both. But if you only have a current power of attorney, it is only valid while the person who grants the power of attorney has capacity. And once they lose their capacity, that document becomes null and void and finished forever.
I think you answered this before, but just to be clear, can they make medical decisions? I'm assuming they are referring to the attorneys.
Attorneys cannot make medical decisions under the current regime, no.
Okay. So if someone set up an enduring power of attorney, but they are now not happy about it, can they set up another with a different solicitor?
As long as they have capacity, as I said, they can revoke the existing enduring power of attorney. There is a process they have to go through to do that, including getting a medical certificate to say they have the capacity to understand what the revocation entails. And then, yes, they can set up a new one, which again requires the notice parties to be, requires people to be notified, requires another medical certificate. Um, but yes, if they still have capacity and if doctors are prepared to certify that they have capacity, they can do that.
The next question, as ward of court is still in place until the new law is implemented, do you have a fact sheet on ward of court that could be given to families in the event that the person they are caring for has lost capacity to make decisions?
I would have some information, but people can find a very helpful booklet on the, if you just look up online, Wards of Court, the Wards of Court office has a very helpful online leaflet, if you like to call it that, that people can access, and it does give reasonable information also. But equally, I have some information I can give to people.
Does EPA require to medical capacity reports for people living with dementia?
No, the only, as I said, when you're setting one up, it requires a doctor to sign a certificate. And if the document needs to be activated, it also requires a medical certificate at that time to say that the process needs to be activated. Whereas, for example, in order to apply to make somebody a ward of court, you do need to get 2 medical certificates from 2 individual doctors who each see and examine the person within a month of each other at the start of that process.
Can a solicitor refuse to complete an EPA for a person living with dementia, even though a medical capacity assessment has been carried out, stating that in their medical opinion, the person has capacity?
Yes, they can.
Okay. What is the procedure if the blood relatives signatories predecease the enactment of the power of attorney? I think you mentioned that one previously.
Yeah, there's a process in which that can be explained, and you would then just notify whoever is deemed to be the next appropriate person to be notified.
Yeah. If there's no family, are care dementia staff okay to request an EPA if that's what the client wants?
And anybody can introduce the notion of creating an enduring power of attorney to the individual. And then it's a question of the solicitor and the doctor coming to a conclusion that the person knows what they're doing, knows what they want to do, and is willing to proceed on that basis. So yes, is the answer to that.
How do you see this role changing with the full enactment of the Assisted Decision-Making Capacity Act?
I'm not holding my breath anyway for the enactment of the act. So the function of the enduring power of attorney is not going to be changed significantly. And there will be some changes if the act is commenced as it currently stands. There will be more oversight. There will be more people involved in the process of notification and certification when the document is being signed. And there will be significantly greater reporting requirements on the attorneys under the new legislation if it comes to it, because the attorneys under the new legislation are going to have to, by law, file an annual set of accounts with the new Director of Decision-Making Services, setting out how they believe they are managing the person's affairs in the person's best interest. So it is going to be significantly more time consuming, significantly more complicated, and as a consequence, I am reasonably sure it's going to be significantly more expensive. But it hasn't happened yet, and depending on who you speak to, some people are suggesting it might be activated in the latter part of next year, but I'm not necessarily sure that that'll happen.
A related question just came in when you're just talking about the costs. Can you give us an estimate about what the cost is to set up an enduring power of attorney, roughly?
Well, that will vary from solicitor to solicitor. I have heard of fees of, you know, €200-300 up as far as 18 or 1900 euro. I think somewhere between those figures is more appropriate. So people can ask around, but the cost does vary. But from a solicitor's perspective, it is a very onerous document that does need to be attended to properly. And in my experience, the lower end of the fee scale would not be appropriate.
So the next question here is from someone who actually says that they have an unactivated enduring power of attorney for the father who has stroke-related fluctuating cognition. So this person is afraid to actually use any of the father's finances and is using their own at the moment because I guess they're afraid of repercussions. Do you have any advice for this person?
I would recommend that they seek clarity from the treating physician to ascertain whether or not the doctor feels the enduring power of attorney should be activated. And if it is, that process should be started, and then that individual can ultimately and would be entirely within their rights to seek a refund and obtain a refund of whatever funds have been spent. Well, as I said, attorneys have an obligation to make an application to register if they feel the person has become or is becoming incapable of managing their affairs. If an EPA is activated and the person does recover, well, then an application can be made to cancel it. That wouldn't happen very often. In fact, I'm not aware of it ever having happened. But if somebody regains full capacity, but in any event, ask the doctor.
Can an enduring power of attorney be done on free legal aid?
I don't believe so.
Okay. Thank you, Mark. That was really informational.
You're very well.
I hope everybody else enjoyed it like I did. Thanks for your time.
Thanks, everybody.